international public law belongs to the genus private law. This is what Hersch Lauterpacht famously wrote in 1927 in his dissertation entitled Private Law Sources and Analogies in International Law. Lauterpacht based this private law analogy on the horizontal structure of international law and on the facts that states pursue their individualistic interests on the international plane as opposed to caring for the common welfare, for the, as we would say today, global public interest. As for the private law sources, Lauterpacht showed that international law has emerged out of Roman private law building blocks. The private law, originally Roman law models available, have throughout the formation of international law been applied to the interactions of states as the quintessential public actors. Indeed, international law has been designed analogous to private law. It conceives of states as dealing with each other on an equal footing, so to speak horizontally. States enjoy sovereignty, analogously to natural persons' private autonomy. States conclude treaties on the basis of mutual consent, analogous to private law contracts. And states incur state responsibility in a private law liability style. Also, the concept of customary law, titles to territory, and the notions of self-defense, these are all legal institutions derived from the domestic, ultimately Roman, private law. But these private law-like features of international law have been considered unimportant by a different strand of thought. Building on the jus naturae et gentium, 18th and 19th century diplomats, Gabriel Bonneau de Mably and Charles de Talleyrand, spoke of a droit public européen. Textbooks, abandoning Latin as the scholarly language near the end of the 18th century, were initially entitled Law of Nations, Droit des gens, and Völkerrecht, respectively, but the first publicized book titles appeared at the end of the 19th century, in French, Droit international public, and almost simultaneously as Public International Law in English, a handbook by Thomas Lawrence. Today, French textbooks by far prefer the title Droit international public over Droit international, whereas English textbooks predominantly call themselves international law, but not so often public international law. We have, of course, the notable exception, namely Brownlee, as continued by Crawford, that's public international law. I submit that this usage of the label public for public international law conveys a deeper meaning, and that maybe the slight reluctance by English authors is owed to the Dicey heritage, which, however, distorts Albert Van Dicey's intention. As you know, then Albert Dicey had found in his introduction to the study of the law of the Constitution the continental scheme of a specific administrative law, I quote Dicey, foreign to the fundamental assumptions of our English common law. But Dicey was not in principle against the distinction between two subfields of law in England. He was just opposed to privileges and exemptions for the administration. Dicey was all in favor of the rule of law. And his point was that also the administration must be subject to the rule of law. So if anything, Dicey supported or would have supported the idea that states, their administrations and their governments should be subjected to the rule of law. And that is one feature that we today associate with the label public law. So international law is indeed public law because it subjects states to the international rule of law and because it is a law which, among other things, tries to reconcile potentially conflicting national interests to further a global public interest. In the last decades, and notably in the 1990s, international law has developed ever more public law-like structures and features. This includes publicized lawmaking, that is more under the public's scrutiny than traditional secret diplomatic negotiations. It includes an administrative law-like functioning of international organizations, and it includes the proliferation of courts and tribunals which control states and which issue binding top-down judgments and awards. Finally, constitutional principles such as the already mentioned rule of law, human rights, and arguably even proto-democratic features such as transparency and participation for civil society actors form part and parcel of international law as it stands. But This trend of publicization of international law has in the last decades been accompanied by a seemingly contrary trend of privatization. Privatization, relevant for international law, comes in two kinds: the privatization of international law and privatization under international law. I use the term privatization of international law to describe the fact that global markets, global corporations, and global supply chains have begun to shape not only the substance of international law, but also its structure in terms of legal subjects and in terms of legal sources and instruments. This is due to a rise in power of private actors, and that is, for the purposes of this lecture, business actors, and due to an increasing resort to private law instruments, both by states and by international organizations. As I said, by private actors I mean business. This lecture is not concerned with NGOs. I do not treat NGOs as private actors with a personal or profit interest, but as civil society actors pursuing public regarding objectives. Speaking with Hannah Arendt, NGOs belong neither to the public nor to the private realm, but to a third sphere, the sphere of the social, as distinct from the private and the public spheres. In current governance arrangements, civil society actors form indeed part of a governance triangle, together with states or international organizations and with business. And of course, there are numerous hybrid entities, mixtures of profit and non-profit societal actors, which I will leave aside. In our fully developed 20th century capitalist system, the raison d'être of economic enterprises acting on a market is to make profit. The business of business is business, as Milton Friedman quote. Throughout the history of company law, this has not always been so. To the contrary, chartered companies, which emerged out of the medieval guilds and out of religious and academic corporations, were until well into the 19th century considered public actors, entrusted with a task to contribute to public welfare. The same was true for the overseas trade companies, such as the British East India Company, an extremely powerful international actor. The British East India Company, as it is well known, went to war, conquered territory, administered territory, provided protection, inflicted punishment, regulated economic, religious, and civic life, conducted diplomacy, and made claims to jurisdiction over land and sea. The company was granted by the Mughal king in 1765 the official status of a Mughal Diwan, a chief revenue officer with the right to collect taxes for the provinces Bengal and Bihar in the Mughal Empire. These powers led Edmund Burke to qualify the company as a state in the disguise of a merchant. With a view to the company's extensive powers, the British East India Company has, in recent historical research, been analyzed not only as a quasi-sovereign, but as a full-fledged corporate sovereign, as a company state. But the East India Company and the other overseas trading companies date back to an era when such a thing was not strange but typical, in an early modern world filled with a variety of corporate bodies politic and hyphenated, hybrid, overlapping, and composite forms of sovereignty. The contemporary republicization of big business through the evolution of global corporate responsibility standards and potential human rights obligations is an important theme of these lectures, to which I will return at the end of the third day. The rise of the private sector, that is business, both inside leaner states and on a global scale, the concomitant transformation of states, and the deep engagement of international organizations with private partners have been transforming the international legal persons themselves, have been transforming the international lawmaking processes and the legal outcomes too. First of all, privatization in states arguably modifies these states and their governments. This matters also for international law, which does not treat states as black boxes. When private contractors function as the fourth branch of government, as the New York Times found it 10 years ago, then this is relevant for international law. Privatization has, it is argued, transformed state sovereignty. It has diffused sovereignty, or, to use Anne-Marie Slaughter's term, it has disaggregated states into network structures. This brings us to the question whether the transfer of state functions, tasks, and services to private actors is a mirror image of the transfer of public functions to international organizations. Is buying security from companies such as Blackwater or DynCorp, to name some prominent military contractors, is that the same as the transfer of economic sanction power to the EU and entrusting the United Nations with peace missions? Are both kinds of transfer similar because both modify statehood and authority or power? Or are they fundamentally different because DynCorp is private while the UN is a public actor? This brings us to the core question of the lectures, to which I will revert at the end. Before going into details, let me give you an overview of the 3 evenings. In the second lecture tomorrow, I will deal with the privatization of international organizations. Here we find a gamut of phenomena which all have to do with the extension of private law instruments and with a private law logic within the sphere of the organizations. We see a full privatization of some organizations in the area of telecommunications, satellites, and air traffic. The relevant organizations have been transformed into private business entities as a result of the liberalization of the industry sectors. Second, and much less radical, is the realignment of the internal structures and operations of international organizations along a market logic oriented to clients in the style of a new public management, NPM. Third, I will look at the international organization's use of private law instruments, namely contracts, in order to equip themselves with the goods and services they need to perform their public functions. Fourthly, the organizations cooperate with business actors in more or less loose formats and so-called public-private partnerships, PPPs, in order to realize objectives in the public interest, and sometimes this amounts to the creation of hybrid institutions. Fifth and finally, the international and regional financial institutions are nudging or pressuring states to engage in privatization proper in internal infrastructure adjustments. These 5 quite different phenomena raise specific questions of international law, some of which I will try to analyze tomorrow. In my third lecture of Thursday, I will approach the phenomena from the other side, namely from the private sector side. Business is, of course, always involved in the various types of privatization I mentioned, at the receiving end. The private actors' contributions to international governance are so manifold that I will concentrate on certain business activities which seem most interesting in legal terms. I will deal with global lawmaking and standard setting by private actors, and second, I will examine the recalibration of public and private actors and of public law and private law instruments in 2 dynamic issue areas, namely internet and investment protection. One question of lecture 3 will be how international law shapes, conditions, and limits the private activities, and notably the performance of former state functions by private enterprises as a result of domestic privatization. Private actors are, as a rule, under the law as it stands, not directly saddled with international human rights obligations. I will moreover argue that it is indeed preferable to strengthen only the so-called indirect horizontal effect of international human rights through the enactment of domestic law, through the contracts between states and business, and through the interpretation of those instruments in conformity with human rights. So far my outlook over the 3 evenings. And in this first lecture tonight, I will only deal with the second kind of privatization under international law, which I have not yet explained so far. States have radically and often under pressure by international and regional financial institutions divested themselves of infrastructure and have handed over tasks and services to the private sector, ranging from railroad over electricity to postal and telecommunication services. Of course, we're all familiar with this because the UK has been pioneering this trend in Europe. It is well known and has been well studied, notably by administrative lawyers. It is far less obvious that international law has something to say on this, 2. I must therefore first justify why I call it privatization under international law. Does such privatization come at all under the purview of international law, or is it not rather in the domaine réservé and outside the scope of international law? Privatization has traditionally been considered a matter of political discretion, at best regulated by domestic constitutional law, but not by international law. For example, Uruguay has a constitutional prohibition to privatize essential water utilities. The existence of international law rules on privatization on top of domestic rules would make a difference, because states can change their laws and amend their constitutions, for example, to allow future privatizations. In contrast, of course, rules of international law cannot be changed unilaterally by the state alone. The opposite of the internal privatization of infrastructure I just mentioned is the nationalization of land or of industries. Strikingly, nationalization is regulated in some detail by international law, with rules on expropriations and on compensation. In contrast, privatization has largely, until very recently, escaped the attention of international lawyers. Indeed, no specific international rules in treaty or customary law on privatization within states exist, which would provide a distinct framework or regime. To the contrary, the legal principles of state sovereignty and of the self-determination of peoples protect the states and the people's choices of their political, social, and economic system. These legal principles shield and respect a state's sovereign decision to engage in privatization. It has therefore been repeated mantra-like that international law, especially international human rights law, is neutral towards privatization. This mantra is drawn from the UN Social Rights Committee General Comment number 3. I quote the General Comment: "Thus, in terms of political and economic systems, the covenant is neutral, and principles cannot accurately be described as being predicated exclusively on the need for or the desirability of a socialist or capitalist system, or a mixed, centrally planned or laissez-faire economy, or upon any other particular approach." End of quote of the Social Committee. I submit, and here I follow Manfred Novak, that this ostensible neutrality of international law, which had been formulated in the General Comment of 1990, still at the end of the Cold War, and which has regained relevance in the Cold War-like times we are living in now, that this General Comment relates to the overall form of political and economic systems, but that the neutrality claimed here does not really relate to deliberate privatization programs. With this, I want to say that privatization does not completely lie inside the domain réservé. As a purely factual matter, states undertake privatization because they need money, and their budgetary situation is of course heavily determined by the reality of interstate competition, including tax competition. Second, privatizations increasingly involve transfers of state land, of assets and other holdings to foreign companies. And already through this fact, privatizations acquire an international dimension. It can truly be said that privatization is an important part of globalization because it involves global players. Third, privatization is occurring in the fields of foreign affairs. States go to war with help of private military contractors. States distribute official development assistance with help of private firms. And states allow corporate diplomacy to some extent. Another matter is, fourthly, that states use the forms and instruments of private law while retaining full control through financial or legal means. This is often called a formal privatization or a sham privatization. And this formal or sham privatization also happens on the international realm. For example, states enter the global financial market through sovereign wealth funds, and states extract natural resources abroad with help of state-controlled or state-owned industries. So all these various forms of privatization in states are factually determined by international relations. But privatization has also legally come under the purview of international law. There are three aspects to this. First, privatization in states has triggered the creation of new regimes of international law and has crucially shaped these regimes. I can give some examples. First, anti-corruption. The international conventions combating corruption are mainly the result of large-scale privatizations in Central and Eastern Europe due to the dismantling of former socialist state enterprises. The privatization of these huge industries and the enormous market opportunities opening up there has given rise, as it is well known, to enormous corruption as well. This has stimulated the adoption of the meanwhile dense net of international and regional anti-corruption conventions. And it remains the case that public procurement, which is not privatization in a narrow sense, but an important engagement between public actors and the private sector, that public procurement continues to be the most corrupt area of the economy. So here, the international anti-corruption regime is most relevant. This brings me to the WTO General Procurement Agreement of 1994. The GPA embodies principles for safeguarding the equal treatment of competitors for business opportunities and requires members of the agreement to pursue administrative or judicial review for bidders and contractors. The GPA also encourages states to give some preferential treatment to bidders from developing countries and thereby seeks to promote the international community's development law objectives. So this is an important international legal regime specifically dealing with public-private interactions. My third example for international law being shaped by privatization is the human right to water. This human right was actually, one could say, found as a critical reaction to the large-scale privatizations of water utilities in Latin America. These privatizations were in turn a core component of infrastructure programs suggested by the international financial institutions based on the Washington Consensus. The UN Human Rights Committee's General Comment number 15 of 2003 on the right to water and other UN documents conceptualized the new human right as an extension of the rights to food and to health. This was the plain result of a fight against the privatization of water, a result of the so-called water wars in Latin American states, against the exploitation of the human need for water by a few large transnational corporations such as Vivendi, Aguas Argentina, Azurix, and so on. This brings us to international investment law more generally. The most spectacular investor-state arbitrations have arisen out of the privatization of infrastructure, enterprises sold by governments to foreign consortiums. These arbitrations have, roughly since the 1990s, shaped an entirely new field of international law. This is of course well known, but it is not so widely known that the foreign investment came out of privatization exercises. Fifth, international treaty makers have reacted so as to prevent the evasion of states from obligations through privatization. The best example is the anti-torture regime. As you know, torture is legally defined in the Convention Against Torture as the infliction of pain by a public official. The privatization of prisons in many states risks to bypass the prohibition of torture, thus narrowly defined. The optional protocol to the Convention of 2002 therefore explicitly states that, for the purposes of the protocol, deprivation of liberty also includes a private custodial setting. CAT General Comment number 2 of 2008 says, I quote, "Where detention centers are privately owned or run, the committee considers that personnel are acting in an official capacity on account of their responsibility for carrying out the state functions, without derogation of the obligation of state officials to monitor and take all effective measures to prevent torture and ill treatment." So the protocol here defines the private employee as being a public official. But it's not only the case that privatizations have shaped international law and new international regimes, the inverse is also true. International law has decisively shaped domestic privatization processes. Privatization programs in states have been, as I mentioned, suggested by international and regional financial organizations to the states. Let's revert to the Washington Consensus of 1990. Economist John Williamson had coined the term initially as a description of the attitude of the Washington-based international financial institutions, that is World Bank and IMF, and of the US-American administration. But Williamson's 10 points soon mutated from a policy description to a policy prescription. privatization of infrastructure was one of his 10 points. Importantly, privatization under the Washington Consensus was to be monitored by the international financial institutions. 25 years later, the Washington Consensus has come under heavy fire. But despite critique against the excesses of privatization and neoliberalism, privatization has again been fueled by the financial and economic crisis of the new millennium, including the European debt crisis after 2011. Privatization programs have been made a condition for lending to Greece, to Portugal, and to Cyprus, to name only the most important states affected. The basis of privatizations were, as it is well known, the letters of intent and memorandums of understanding signed by the European Troika, composed of the European Commission, the European Central Bank, and the International Monetary Fund on the one hand, and these states on the other hand. For example, Greece in 2012 signed a memorandum with the Troika which says, I quote, "The government implements the privatization program with the aim of collecting 50 billion euro in the medium term." The 2015 MOU with Greece says, I quote, "To preserve the ongoing privatization process and maintain investor interests in key tenders, the Hellenic Republic commits to proceed with the ongoing privatization program." So Greece committed, in the language of the MOUs, to privatize its maritime ports, electricity companies, gas companies, and regional airports, and the latter is ongoing. 2 years ago, Pakistan has committed itself, I quote the project data sheet of the Asian Development Bank, to the implementation of a comprehensive and robust privatization and restructuring program as a condition for financing by the Asian Development Bank. Last year, in 2016, Zimbabwe has committed to a review of state enterprises to get money from the African Development Fund. And also the IMF and the World Bank, despite all the critique against the Washington Consensus, they are still propagating privatization measures, albeit under a different name, notably in the poverty reduction strategy papers. I will deal with the international legal obligations surrounding privatization, falling on those international and regional financial institutions themselves, in Lecture 2 tomorrow. And I will give you only the summary here. I submit that the international organizations encouraging states to privatize are, in law, under a specific obligation to protect social human rights. They must not frustrate the attempts of states to honor their social human rights obligations. This brings me to the limits of privatizations. If privatization in states is not in the domain réservé, as I just showed, then international law has a say on it. Because privatization is a decision of economic policy, states enjoy a large margin of appreciation here. Nevertheless, privatization is shaped and potentially also limited by international law. For Daphne Barak-Eres, we might divide privatization proper, the privatization of infrastructure and services, into 3 phases. First, the decision whether to privatize and possible limits. Second, the process of privatization, in which participation and other procedural issues might play a role. And third, the regulation after privatization. So privatization raises 3 questions. The questions of the if, the question of the how, and the question of how far. International law does not contain rules on the if. It does not say anything on the question whether to privatize. States are under international law free to pursue a policy of privatization. It's their free choice, it's a sovereign decision. However, international rules on the how, in which manners and procedures to privatize, and also how far exist. International law can hardly prohibit states from dismantling or dissolving themselves. But it could be argued that states may not divest themselves of their core while continuing to claim to be states. This would be a self-contradictory behavior which is frowned upon by law. But then the question is, what is the essence of statehood? Is there a hard core of essential statehood which may not be given up? In order to identify such an essence of statehood, one could first look at a certain issue area or policy field or related to this at certain state functions. I submit that there are no inherent state policy fields or functions. There is no universally agreed upon definition of what are inherently governmental functions, tasks, or services. The idea of some inherent governmental function has therefore properly been called an inherently governmental fiction. The essence of statehood is a matter of ideology, and ideologies have ranged from the minimal state a la Nozick to the full-fledged Scandinavian welfare state. However, there are, if no inherent state or governmental functions, some typical public functions or tasks. A public task is one whose positive delivery lies in the public interest of a collective and whose delivery may produce negative externalities. This includes the production of public goods in the economic sense of non-exclusive and non-rival goods, such as security and clean air, assuming that this concept of public goods is sound and that such goods exist, but public functions go beyond the furnishing of public goods. However, what exactly lies in the public interest has been viewed differently throughout history and has been shaped by different national traditions. Most people would intuitively assume that protection from criminality, defending the country, making laws, and upholding the financial order are such public tasks. But basically, all these tasks have already, at some places, been outsourced and privatized. For example, governments hire private law firms to draft their laws. Or bitcoins are a privately created and privately administered currency with which you can buy and sell goods. Against such experiments, we must admit that which tasks should definitely remain public cannot be defined by experts, but need to be identified in a political process. Also, in the real world, any privatization starts not in a vacuum, but in a state already doing something. For example, the Greek state running airports. This state of affairs matters because it has created legitimate expectations by the users of that service. Also, it must be taken into account that once a state infrastructure has been dismantled, for example, school or hospitals, and when then private providers pull out of the market, it will normally be difficult for a state to resume the function again. If these factors are duly taken into account, and if the decision to privatize is made in a public procedure, with participation of affected populations, then no taboo issue area or taboo function would seem to exist. A different way to identify absolute limits to privatization is to look not at issue areas or functions, but at the specific means which the state has at its disposal. According to Max Weber, the state is defined by its monopoly on the legitimate use of force. Starting from there, it has often been said that states are prohibited from divesting themselves of the essence of their statehood by privatizing prisons or the army. As you know, all this has been happening. At this point, we should mention that the United States has by far the highest numbers of prisons worldwide. Almost 25% of the world prison population as compared to about 5% of the world population. And the US also has the highest incarceration rate, roughly 150 prisoners per 100,000 inhabitants. Statistically, no correlation exists between the crime rate and the incarceration rate. And the most dramatic increase in the US-American prison population is coincidental with a high time of prison privatization in the USA in the 1980s. Theorists of a prison industrial complex suspect that the security providers and the prison lobby are so influential that they have contributed to this incarceration trend in the US. Again, the question is whether international law has a say on this unfortunate development. It has been claimed that Max Weber's definition of the state is neither factually correct nor normatively useful. As for the facts, many states, notably in Africa, do, in fact, not enjoy a monopoly on the use of force. And as for the normative side, it is a long-standing Marxist critique that the distinction between state and private coercion is problematic. The Marxist and post-Marxist claim is that state violence stands behind the corporate, property, contract, and criminal law that define and enforce private power relations. I would respond that these observations are beside the point. The factual problem that some territorial entities called states are failing or unable and do not live up to the legal concept of the state does not alter the usefulness of such a legal concept as long as it is able to capture most phenomena in the world. As for the normative critical objection, equating state power and private power, this objection goes to the core of this lecture, namely the distinction between the public and the private, and I will return to it at the end. As far as legal practice is concerned, real life does seem to reflect Max Weber's definition of the state as possessing a monopoly on the legitimate use of force in a given territory. Currently, all states seem to exclude or frown upon entrusting private military and security contractors with active combat functions. In the domestic privatization debate, it is, along this line, often thought that tasks having to do with the specific disciplinary means at the disposal of the state are difficult to privatize. This concerns the imposition of criminal punishments, the use of deadly force other than self-defense, policing, gathering of intelligence, and so on. Notably, the privatization of prisons does remain controversial, although, as I said, it is practiced, notably in the Anglo-Saxon world, but other states are reluctant to privatize prisons. Both the Israeli and the German Constitutional Court have recently placed limits on the privatization of prisons, but with different justifications. The German court has found the serving of a criminal sentence in a prison or in a closed psychiatric facility to lie in the core of public activity. The German Constitutional Court defined this core state activity on the one hand by pointing to the specific means which the state has at its disposal, namely command and coercion. But secondly, and somewhat confusingly, the court linked this to the fact that this coercion, I quote the court, directly limits fundamental rights protected by the Constitution. The Israeli Supreme Court, sitting as a high court, relied on a different argument. It reasoned that the state is based on a contrat social, on a social contract in which the state is given the responsibility for public security, of which it may not divest itself. I quote the Israeli High Court. Imprisoning persons in a privately managed prison leads to a situation in which the clearly public purposes of imprisonment are blurred and diluted by irrelevant considerations that arise from a private economic purpose, namely the desire of the private corporation operating the prison to make financial profit. End of quote. The operation of a prison on a profit-making basis turns the prisoners into a means, reflects a lack of respect, and therefore violates human dignity, concludes the Israeli court. The reasoning of the Israeli Supreme Court is symptomatic for a shift in the debate. The Max Weber-style limits on privatization were articulated in terms of objective law, in terms of institutions, rather than in terms of subjective human rights. It is a rather novel claim in the legal debate on privatization that international human rights law defines the outer limits of the state's margin of appreciation when undertaking privatization. The novel focus is on the populations affected by privatization, on their rights. Rights at stake are the personal liberty and rights of detainees in prisons, the personal security affected by private military and security contractors. In extreme cases, human rights arguably even constitute absolute limits, as the Israeli Supreme Court had argued. But the rights most discussed are the social rights. We are talking here about the rights to health, the right to education, to water, to social security under the UN Social Covenant. Indeed, the UN Covenant on Social, Economic and Cultural Rights has gained entirely new prominence in this current debate on privatization and austerity. It has been claimed that the Covenant prohibits states from privatizations without a proper human rights impact assessment. Also, The presumption against the admissibility of retrogression requires states to justify cogently the dismantling of previously public services. This is notably what the chairperson of the Social Rights Committee has spelled out in her famous letter to state parties concerning austerity measures of 2012, which I reference on the handout. Also, the Special Rapporteur on the Right to Education recently called for a regulatory framework for governing private providers centered on education as a public good. And the Special Rapporteur asked, I quote, "The commercialization of education by all kinds of for-profit operators, all with objectives contrary to international commitments by states and national values, must be stopped and must be sanctioned." Also, the UN Social Committee, in its various general comments on health, warns against privatization of the health sector. Importantly, the Social Committee is preparing a new general comment on state obligations under the covenant in the context of business activities to be adopted in summer this year. The draft text is already public. I reference the draft text of this new general comment on the handout. And I also printed you the passage explicitly on privatization. Here the two drafters note that this general comment is adopted at a time when privatization is a growing trend in many parts of economic, social, and cultural life worldwide. They continue, the increased role and impact of private actors in what used to be predominantly public sectors pose new challenges as regards the affordability of goods and services. States parties should ensure that privatization does not lead to a situation in which the enjoyment of covenant rights is undermined by the inability to pay, at the risk of creating new forms of socioeconomic segregation. States, says the draft, retain the obligation to regulate and ensure that private actors provide affordable access to quality services to all. The draft text even seems to ask states to adopt general anti-discrimination laws which would govern the private sphere. So, this new general comment, assuming that the draft's substance will remain unchanged, postulates a strong state obligation to regulate, including regulation which imposes universal service obligations on the private providers. Notably with regard to infrastructure, especially public transport, also the ancillary right not to be discriminated against on the basis of one's material status, namely poverty, in the ambit of covenant rights, provides some leverage against excessive privatizations. If, for example, the privatization of local buses would lead to terminating the transportation service to living quarters of the poor, this has a disproportionately negative impact on persons with low income. If people without own cars can no longer reach their workplace in time, then this might be qualified as amounting to an indirect discrimination in the ambit of the right to the opportunity to gain one's living by work under the social covenant. At least so the argument runs. For many, these arguments are going a step too far. The assertion that human rights, notably international social rights, are really capable of placing effective limits on privatization has sprung up only in the last few years in the context of privatization measures incited by international financial organizations and attacking those institutions more than the states themselves, such as Greece. This novel human rights-based approach to privatization manifests the fragmentation of international law. While the IMF imposes austerity, the UN Social Rights Committee criticizes this. And as we all know, a unified forum to debate and balance the competing interests and find a compromise is missing. The real lacuna is not the lack of a world state, but rather the lack of one political forum. The UN General Assembly can discuss the matter, but it cannot decide. It is an open question for me whether this shift of attention from institutional consideration to rights of the end users and recipients of formerly public services within the privatization debate and tangled with the austerity debate is a positive development in terms of legal systematics and as a matter of legal doctrine. What are the risks and opportunities of this rightsification? Does not the new focus on rights erroneously depoliticize the debate? Or is, on the contrary, the human rights focus an asset because it places on states an obligation to justify, which again opens up the space for political discourse? I will come back to this question, to the potential problem of a rights inflation within the international legal discourse, in my third lecture. The international human rights bodies have spelled out some conditions on privatization processes. Some of them are already part and parcel of international human rights law and general international law as it stands. Others are only policy proposals, de lege ferenda, governing privatization in states. First, states seeking to undertake a privatization program and international organizations nudging them to do so must properly identify potential consequences, both positive and negative. They must define the objectives to be achieved and impacts on interests, possibly on rights, of affected groups. Second, states must balance the expected benefits against the harms for the affected groups, also applying the principle of necessity, consideration of alternative measures, reasonableness and proportionality. Necessity must be assessed mostly in regard to efficiency gains. Can these not be achieved otherwise? Will the privatized services really be more efficient? Third, states and also the involved international organizations must consult the affected groups, for example, rural populations, with regard to railway privatization. Such consultations must be guided by the principles of inclusiveness and transparency. And fourth, under the principle of legality, which is part of the rule of law, privatization needs a legal basis. It needs an enabling law, definition of the processes of law. Fifth, the state must foresee some form of remedies and access to review for affected groups. And sixth, the state must create effective regulation for monitoring privatization. 7, states should establish independent and impartial monitoring bodies with an appropriate mandate. And 8, states must foresee a universal service obligation, USO, either by contract or by statute. Such a universal service obligation is a standard tool in the telecommunications sector and is, for example, foreseen by the relevant EU directives. This USO needs to be extended with regard to the privatization of essential services, namely provision of water and electricity. The locus of all these regulations may also be the contracts themselves. Importantly, all these conditions are no material limits. They are all procedural conditions. The expectation is that procedures for deliberation and for the participation of stakeholders will in the end determine the limits of privatization. So the expectation is that the proper substance will result from the debate. This is submit an appropriate approach to international law, which does not, in order to maintain its universality, set many substantive standards. To conclude, international law, notably international human rights law, appears to furnish some benchmarks to evaluate privatization. We can now, in hindsight, say that the laissez-faire privatization, that is privatization without a proper legislative basis and without proper regulation, as started in the 1980s and 1990s, was one of the dark sides of globalization. By admitting this, we recognize the profound ambivalence of states, which may be overly powerful, corrupt, and potential menaces of human welfare. However, we now see more clearly than maybe 20 years ago that functioning states are also the main guarantors of stability, human rights, and justice. International law protects state sovereignty, but this comes with a responsibility for the welfare of humans under their jurisdiction. If states outsource functions and services, international law does not allow them to escape or relinquish their responsibility. State sovereignty/responsibility requires that states regulate and monitor the outsourced functions. So the current climate of privatization has, generally speaking, brought about, and that's I think quite interesting, brought about a shift from state obligations to fulfill to the obligation to protect, ensure, and oversee. So importantly, international law does not only protect the right to regulate, as the WTO appellate body puts it, but a state obligation to regulate. And as we have seen, this obligation is nowadays being articulated in terms of a responsibility for safeguarding rights, rather than in terms of sovereignty. The necessity to actively regulate privatization requires agencies and complex rules. This means for states which do not have this regulatory capacity, that privatization risks to bring them into non-compliance with human rights obligations as defined by the monitoring bodies. And this in turn suggests that specifically non-Western states, which have been ushered into privatization in order to eliminate corrupt bureaucracies, are exactly the ones where privatization does not work either. So does not this catch-22 demonstrate that my insistence on the state's guarantee role, coming with the human rights-based approach to privatization I just sketched out, is a useless reification of an illusionary distinction between private and public threats, and between public and private responsibility? Is it not erroneous to assume that international public law, hooking onto the states as public actors, is in fact something above the corporate economy that acts as a limit on corporate power? Does not this liberal approach, which emphasizes the role of the state, in reality unwittingly reinvest the corporate sovereign powers it seeks to subvert? Is it not time to acknowledge that international law has not been designed for constraining and will never be over and above the private market forces, but that on the contrary, international law mutually constitutes public sovereignty and the private and global corporations? Let us at this point recap the classic critiques of the public-private distinction, and with it the distinction between public law and private law. These critiques are old, but maybe they have regained force in the current constellation of global corporocracy. The Marxist critique and its progenies concern mainly the economic sphere, and have been arguing that economic power is as seriously dangerous as state power, that ultimately capital governs, and that law is only a superstructure to the material conditions of production which determine class. The feminist critique has been directed against splitting off the private sphere of the household and family from public life. Feminists rightly point out that the freedom left by the state to the private actors will be exploited by the powerful one, because there is in reality no state-free zone, but all constituted by the state. Leaving a realm of private freedom in reality means to partisan with the powerful side. As Catherine McKinnon put it, the law of the private realm is designed to keep some men out of the bedrooms of other men. After all these critiques, we easily accept that there is not one public-private distinction, but that there are many and that these are limited and tentative. With regard to the law, I would like to revert to the merits of qualifying international law as public international law, which I evoked at the beginning. The distinction between public law and private law is, like gender, partly constructed. Each side is associated with features that are not necessarily inherent, but which are to a good part imagined, associated, and then stereotyped. In the realm of international relations, the private law versus public law analogy offers no more than building blocks for distinct sets of reflection and orientation on trajectories for global political, social, and economic change. It would be too simplistic to merely pit a declining power of states against the rule of the global market. But I also think that the neo-Marxist and critical suggestion to see private corporate power as just a mode of public political sovereignty and vice versa is also simplistic. In contrast, I conclude that it makes sense, both analytically and normatively, to uphold the multiple public-private splits. This leaves room for approximating justice on two different, partly competing but also potentially complementary roads: the path of justitia distributiva, to be realized top-down, and justitia compensativa, as realized in the private sphere and through the market. Lauterpacht's original intention of strengthening the element of law in international relations and of countering lawlessness was in 1927 served by drawing on private law as the best available model of law existing at the time. 90 years later, Lauterpacht's quest for a reign of law in what we now call global governance is as urgent as ever. But, and with this I close, Lauterpacht's quest can well be satisfied by acknowledging and by carving out international law's feature as public law, exploiting the historic associations that this sets loose and the imaginary it triggers. By doing so, we can accommodate and integrate the actors labeled private into global governance, and thereby further global justice in two different, often competing but also potentially complementary ways.